Greetings to all. Welcome back to the course Digital Marketing Study. We are in the 7th week of the course, and in the 7th week we are discussing on various key issues that concerns digital marketing. And so far we have discussed about the data privacy and security issues. Also we try to discuss various other key issues. So today yet another important and something which is sort of mandatory, something which is very much regulatory sort of things, that is what we are going to discuss today. So the legal issues. So legal issues we would be discussing it in 2 lectures. In the first lecture, that is today, we will be discussing about the overall framework, various miscellaneous laws, rules and regulations, various acts that govern various activities or various facets of digital marketing. And in the second lecture, we would be discussing specifically on one act that is recently have been recognized or have been approved and established by the government of India. We will be discussing, that is something which is very important rule regarding digital personal data. So it is DP Act 2023. So that is we are going to discuss in detail in the second part of legal issues. So let us start and let us discuss about the legal issues that governs the digital marketing facets in India, and also not only digital marketing, rather the environment in which the digital marketing is being conducted, is being undertaken, that is technology, that is the internet system and various other things. So we know that digital marketing has changed the way businesses promote their brand and products, taking the leverage of internet and technology. So it has completely revolutionized the marketing. It is done today to reach the global audience. So to reach to the global audience, the overall system of marketing has been revolutionized. Now what is happening now? A complete revolution, a complete contemporary practices are being adopted to reach the global audience by leveraging the benefits, by leveraging the techniques of internet and obviously the technology. So in digital marketing, cyber law, that is why becomes a very important aspect, and it plays a very pivotal role in protecting consumers and businesses from a variety of risks. So now what is happening with the advent of digital marketing, due to the exponential growth in the internet and technology, now the companies, they are dealing with more and more data. As we were discussing in data privacy and data security, so the company, they have to deal with millions and millions and billions of data every day. So in that case, it becomes more and more difficult for any organization to manage it, and also there happens to be very critical issues. There happen to be breach, there happen to be misappropriation or misinformation, all those things. So that is why it is something which is very pertinent to have certain rules and regulation that governs all these aspects. So the legal system, you know that every country has got its own legal system where it governs the various institutions, various people, various processes with certain rules, regulation, procedures which are abiding by nature, and in case it is being dishonored, in case it is not considered by any individual or organization, in that case there is a system of penalty, there is a system of imprisonment, or there is a system of awarding punishment. So legal actions can be taken against the person who is not abiding by the rules and regulations of the country, the law of land. So legal system, it is there in any country, but also what is happening, there have been very contemporary, a very constant and dynamic change is happening in the domain of digital marketing, in the domain of technology and internet. And it is so fast paced that legal system is facing tough time to keep pace with the ever changing dynamics of digital marketing. For instance, it took almost 6 years since the Honorable Supreme Court of India, it declared the right to privacy as the fundamental right in August 2017, and by the end to become a full-fledged act, it took almost 6 years, and in August 2023 we are able, as a country, we are in a position to form a very robust, a very full-fledged, I would say very comprehensive DPDP Act, that is Digital Personal Data Protection Act 2023. However, India has now very stringent laws related to cyber crimes, data breach, etc. So, all these businesses, all these brands that are dealing with digital marketing, that are dealing with data of the consumers, they are being governed by these regulations and they have to abide by the provisions laid down by these laws. So, India is one of the fastest growing digital economies in the world, and also we are promoting, the government of India is promoting Digital India scheme, right. So, Digital India scheme is being popularized so as to empower everyone with the digital strength to digitalize every document data, or to digitalize the processes. Various processes have been digitalized nowadays, all these payment system and all these have been digitalized. Then we have got DigiLocker, DigiYatra, all these DigiYatri, sorry. So, all these things now we are trying to digitalize the various government processes. We have Aadhaar card and all those things. So, India is something moving towards the digital economy, and it is one of the fastest growing digital economy in the world with over 1.4 billion internet users. India is a treasure trove for data for the businesses. So, obviously considering the number of internet users, and that only comprises 50% of the active users in India, active users of internet out of the total population, and that too is so much, so much of the data, 1.4 billion internet users are there. So, just imagine how what is the quantum, how big is this data source, and that is why India is the treasure trove of data. And when you have got data, you can analyze those data and you can frame different marketing tactics, you can frame various marketing strategies and campaigns by taking insight from these data. So, that is why data is something which is very important for any organization nowadays. However, the collection, the use, the disclosure of data in India is subject to number of laws and regulations. So, let us try to discuss various aspects and we try to understand which legal framework governs those aspects. Like the legal framework for privacy, we know we have been discussing the importance of data privacy, the importance of data security. So, cyber law, it protects the data privacy of users by regulating its collection, its storage, its analysis, its uses and disclosure of the personal information. So, as I was talking about, now we have got the very new, very robust act, that is Digital Personal Data Protection Act, that is DPDP Act 2023. So, the provisions of this act covers personal data in the digital format, including both data that originally digitally and non-digital data that are subsequently digitalized. So, both the datas which were earlier were non-digital, but now it has been digitalized, and which is originally the digital version, it governs both type of data. So, the provision applies to data processing. So, how the data is going to be processed, whether it is processed within the India or outside India. So, now what is happening, these big multinational companies, we know there are many, I would not name, but there are many social media players. So, they are having a big companies and they have got big user base. So, but they take the data and they collect the data from our country, the users of our country. they are the data principals. So they collect data from these people who are the users of these software or application or social media platforms. Now what they do, they take the data and they process in their home country. So in case they are taking it from here and then they are processing in some other country, but still it is this law is going to be applicable for those data also which are either being processed in the country and or from outside the country. And if it relates to the offering of goods and services to the individuals within India, right. So it also extends certain right to data principals, that is the users. So it also extends certain rights like right to withdraw consent, grievance redressal, access to the information that the company or the business have collected, also to nominate. This is something which is very unique. I would be discussing this when we will be discussing in detail. This act we will be discussing in detail in the next lecture. So I will discuss this. This is something which is new, and this is nominate, which is also not in the contemporary laws in some other countries. Also correction and erasure of personal data. Also, in case the legislature is not being followed, then there is a provision of severe penalty which can go to the extent of rupees 250 crores in case of severe violation. So this is something which is very stringent law, and it has to be because it deals with the sensitive information of the users, of consumers. So that is why it is the matter is also sensitive, and obviously to tackle such a sensitive issue, there should be some stringent law regarding this. But there is again GDPR, that is General Data Protection Regulation of 2016. This is the legislation which is been adopted and followed by the European Union. So it is a legislation that updated and unified data privacy law across the European Union, and this is something, this both GDPR 2016 and CCPA 2018. So they could be considered as the base or foundational rules regarding data privacy. They are the pioneers, I would say, because this GDPR and California Consumer Privacy Act is quoted in most of the literature whenever there is a discussion of Data Privacy Act or Data Security Act. Now we also have a law, a act which is very specific to our country. So the GDPR was approved by European Parliament in April 2016, and it went into effect on May 25, 2018. So there are 7 key principles that GDPR talks about. This is something which is very important. So GDPR, it gives 7 principles that should be followed by any company, by any businesses, by any data collector while handling the data of the consumer, while handling the personal data of the consumer or sensitive data of the consumers. So first is lawfulness. So whatever you do for lawful activity. So whatever you perform, whatever you do, that has to be done for, so that should be correct in the eyes of the law, and you should follow the lawfulness at every stage of your activity. There should be lawfulness, fairness and transparency. This is the very first principle. So your activity or your processes, your procedures, it should be lawful, it should be fair, and it should be transparent. So when we say fair, it means there should not be any discrimination on any basis, and if we say transparency, it means whatever procedure the company is adopting, whatever procedure the businesses are adopting, that should be clear, that should be transparent to everyone. Also the purpose limitation. Purpose limitation talks about that the data should be used for the purpose it has been originally collected. So if it is collected for purpose X, then it should only be used for purpose X and not purpose Y. So that is what purpose limitation talks about. Also data minimization. So you try to collect lesser and lesser minimum data. So bare minimum data which is okay or which is needed to perform any analysis, you should try to collect those information only. You should not collect n number of information in the pretense with the pretext that probably you will use those data in future. So rather, for the time being, if you need any particular data that is going to help, that is sufficient for the information for your current purpose, then you should try to take only those particular data, right. I was giving example in the previous lecture also. So for example, if you are fine with these 3 data, then there is no point of collecting this another 3 data. If it is fine, if your purpose is solved with these 3 data only, so you try to minimize the data. Also, it should be accurate. The data should be accurate and it should be updated. Otherwise, it is going to hamper the privacy, it is going to hamper the sensitivity. Storage limitations should also be considered properly. Integrity and confidentiality of data should be maintained at the highest level. It should be given the highest priority. Also, your accountability has to be fixed. If something goes wrong, if something problematic happens, then the owner should fall on you and you should be held accountable and you should take the responsibility of the same. So, this is 7 key principles that have been put forth by GDPR 2016 Act of European Union. Similarly, contemporary we have California Consumer Privacy Act of 2018. So, this act gives consumer more control over the personal information that businesses collect about them, and these regulations they provide guidance on how to implement the law also. So, on one side it provides the control to the users, to the consumers, and also it provides them the guidelines regarding how to implement the law. So, this landmark law secures privacy rights for consumers, including the right to know, right to delete personal information, right to opt out, and the right to non-discrimination for exercising their CCPA rights. So, it gives the user, it gives the consumers specifically 4 key I would say powers. The first is powers or rights, I would rather say. Right to know, so which data you have collected from me. So, as a user, as a consumer, I have a right to know that what data you have collected, what is the purpose of collecting the data, how you have used the data, what was your process of data collection, how you have stored my data. So, I should have the information about it, and I should have the right to delete the personal information if I do not consent, if I want, or even if I have consented before, but now I do not want to continue with that, I want my personal data to be deleted, then I should have that right. So, California Consumer Privacy Act 2016 of US provides this right to their consumers. Also, right to opt out from email marketing, right to opt out from being contacted. So, that should be given to the consumers, and this we have been talking also when we talked about email marketing, and nowadays when we talked about data privacy, we talked about this, that the user should be given option whether he or she wants to opt in or opt out, and even there is a system of double opt out, right. So, there is a system of double opt out. So, double opt out says that even if you have double opt out or double opt in, whereas you talk about that you have opt in and then you have to reinforce the same by responding to a particular email. So, it is something called double opt in. So, it is something like double layer of authentication, right. So, sometimes it happens that quickly the consumer or the user might have opted in, but when he or the person has to reply on a particular email specifically, then he might be in a cool mind and he can rather take a responsible decision, right. So, that is why there is a system of double opt-in. So, here there is a right to opt-in, also right to non-discrimination for exercising this act. So, there should not be any discrimination on any basis while adopting this act. So, moving ahead are the legal frameworks related to the data security. So, cyber law also helps to protect businesses from cyber attacks. These laws help to protect businesses from data breaches, malware attacks and other form of cyber crimes. Also it helps the users also to regarding their data security, or sometimes it happens that companies they collect the data and they there is a data breach. So these acts, these rules and regulation, they helps or they suggest or they governs all those breaches, all those activities which are not permissible, right. So the first one is, and this is something which is very important, and this is something which is very good and meaningful act which is being followed for quite a long time, the Information Technology Act of 2000, and this have also formed as a base for the new DPDP Act, right. And with this there would be some amendment in this Information Technology Act after rolling out of DPDP Act. So it was enacted by the Parliament of India and administered by Indian Computer Emergency Response Team, that is certain, to guide Indian cyber security legislature, institute data protection policies and govern cyber crimes. Similarly, the US, they have the Cyber Security Information Sharing Act, so of 2015. So it is US federal law designed designated to improve cyber security in the US through enhanced sharing of information about cyber security threats and for other purposes. Then there are certain legal frameworks for IPRs, that is intellectual property rights. So cyber law, it protects businesses intellectual property such as trademarks, copyrights, patents and all those. So these laws help the businesses investment in their IPR and prevent competitors from stealing their ideas. So obviously these companies, they spend a huge investment, they do huge investment in developing the intellectual properties. So there should be some protection that it should not be stolen by the competitor or some cyber criminals. So there should be proper guidelines, there should be proper rules governing these aspects. So we have got a number of rules, we have got number of law regarding it, like the Copyright Act of 1957, the Trademarks Act of 1999, the Patents Act of 1970, the Design Act of 2000, the GI of Goods Registration and Protection Act of 1999, the Digital Millennial Copy Act 1998, and this is of US, right. So apart from this, there must be many other rules and regulations specifically covering various intellectual properties. Then we also have legal framework for anti-spam laws. Anti-spam laws are there. So spamming is one of the serious issues, and this happens when you get unsolicited spam emails, spam calls, spam messages. So there are legal frameworks for this also. So email marketing, as we know, it is very popular digital marketing strategy, but the misuse of email campaigns can lead to spamming and unsolicited messages. So marketer, they must comply with the provisions of anti-spam laws, including providing clear opt-out mechanism. This is something which is very important, that they should provide a clear opt-out mechanism, and accurate email header, the subject or the subject line or the sender, that should be very accurate, and this should not give any misinformation. So that should be taken care of. So violation of anti-spam laws can result in significant penalty and legal consequences. So in the US, they have this Can Spam Act 2003, and here we have got various regulations being laid down by TRAI. So that is Telecom Authority, the Telecom Regulatory Authority of India, and it rolls out various guidelines regarding that telecommunications and all those. So I have just trying to explain here the guidance for sending commercial communication. So this is usually this TRAI, they have a fixed guideline that what the company should follow when they have to send mass email or mass messaging. If they have to do, then what should they should follow, that is very much clear. and guidelines are very much clear. It says that the company, they should become a registered sender, so they should apply in a proper format is there, and they should apply and they should become the registered sender, and they should have registered the header. So we know like this AX dash PYTMBK. So this is from Paytm Bank. So this is the header. Sometimes you might have VD dash something like this. So they have to register their header. Also they have to register the content template that they are allowed to send, right? And also only a minimum of changes you can do in that particular template. So whenever you are sending the mass messages or whenever you are sending the mass email, then you also have to provide try the content template, and you cannot vary, little bit information you can vary, and you also provided which are the variable information that might change. Otherwise the overall template should remain same with little changes possible. And also then you also have to submit, you also have to register your customers consent, whether you have the customers consent or not, that you should also provide to try. Then there are legal frameworks for Consumer Act, and this is a very popular Consumer Act you must be aware about. So it is Consumer Protection Act 2019. So it provides guidelines for product liability. So if someone buys a product and it causes some problem, it causes some severe issues with the consumer, then the company should be held liable, right? So it provides guidelines for product liability and consumer rights. So digital marketers, they need to ensure that their advertising are not deceptive and misleading. So it also governs that the various functionings of advertisement, what should be the content of advertisement, what is not correct. So this act also lay down the contents or the guidelines regarding the fair advertisement. So it was enacted to provide better protection of the interest of the consumers and for the purpose of making it more and more robust. So there are very other legal frameworks are there in India, like we have got various online advertising regulations are there, and these gaming apps are very popular nowadays. You must have heard that India have banned PUBG and all. So these have been banned considering the serious problem it is creating with the youngsters, right? And the youngsters, they have the problem of addiction, mobile addiction, and and also they are facing various psychological issues. So the PUBG, and also it was considered to be originated from a country which was not considered to be, it was doubtful, right? The integrity of this particular app was doubtful. So Indian government, they at one moment of time, if you remember, they have selected certain apps that has to be blocked, in which there was PUBG was there, TikTok was there, Cam Scanner was there. So these were the popular apps which were banned. So again we have got rules and regulations for online gaming apps, and nowadays if you see, there are various games, they are becoming very popular. This Ludo Khelo and Ludo Khelo and all these things, these apps are also making cricket team and playing. All these are sort of mobile gambling, sports gambling, sort of all those aspects. So these there are regulations, but they are not very stringent. So probably government should should pay heed to in those areas as well, and try to frame some stringent rules and regulations to cover those aspects also. And then obviously there are regulation related to e-commerce, then there are social media regulations are there, and there are content regulations, and also there are data security standards which covers the aspects of payment system. So there are many other legal, this is not the exhaustive list. Apart from this, there are many other legal aspects are there, various other rules and regulations are there that governs various aspects of digital marketing. So as a digital marketer, you should be, you should be mindful that what your activities are, and you should ensure that those activities are well within the scope of the law of land, are within the well scope of the rules and regulation laid down by the country. So that is all for today's lecture. I hope you have enjoyed the lecture and you have made an understanding that if you have to market your project on the digital platforms, that what sort of rules and regulation that you should be taking care of. So that is all from my side. Hope you have a wonderful time. Have a nice day. Thank you so much.